versus Dean Everett Davis Jr., 2502389FY.
Sorry. Good morning, Your Honor. Assistant Prosecuting Attorney.
Oh, go ahead.
Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Public Defender, for and on behalf of Defendant, Mr. Davis.
Thank you. And you said you are Dean Davis Jr. on the video?
Yes, ma'am.
Quick legal explicable. This is a probable cause conference. Think of it as the court's way of checking whether there's enough evidence to keep this case moving forward. It's like the pregame before the real trial starts.
Thank you. Today's the date scheduled for our probable cause conference. We have a preliminary exam currently set for August 22nd at 10 a.m. Have we decided what we're doing about that hearing?
The defense would like to go forward with the hearing if we could, Your Honor.
Okay. Mr. Freeman, you said you want to leave it on for hearing. Mr. Pfeiffer, you started to speak. I didn't quite catch what you were going to say.
Same sentiment, Your Honor.
Okay. Leave on for preliminary exam. Okay. Preliminary exam is set for August 22nd at 10 a.m. We'll leave it on for that time. It will be in person. Mr. Davis will get you brought over for in-person.
Oof, the judge isn't kidding here. Even jailhouse calls can be used as evidence. Pro tip, everything you say on those phones is recorded. That whole, you have the right to remain silent thing. Yeah, this is why double quotes.
For that particular hearing. Remember that you have a no contact order that applies even when you're in jail. You should remember, of course, no contact with Miss Iwahara, and that applies even if you're in jail. If you're messaging her or talking to her on the phone, the prosecutor can listen to your calls. He can use your calls against you. He can use your calls to add additional criminal charges. You can also face contempt of court for violating a court order. Contempt of court is punishable by 93 days in jail and or $7,500 in fines consecutive to that which you already face. Anything else we need to address for the record for Mr. Davis?
Yes, ma'am.
Whoa, did you catch that? The prosecutor just dropped a bomb. Davis not only confessed on jail calls, but also tried to bribe and threaten the victim into staying quiet. That's witness tampering 101. And it just piled more charges on his plate.
Two things, Your
Yes,
Honor.
ma'am.
Hold on, Mr. Davis. I'm asking the lawyers. Go ahead, Mr. Pfeiffer.
Two things. First, I think it was yesterday, a 10-page supplemental report was uploaded detailing the litany of calls that the defendant has made from the jail in just the brief time he's been in there to the victim and to talk to the victim through his father, where he not only confesses to assaulting her, but also says over and over how she comes to court, he's going to go to jail and he'll kill himself. And then also he's going to have to spend all his money that he was going to spend on her on legal fees, and therefore she just needs to not come to court so she can get that money. So we're going to be adding charges of witness interference and bribery at the exam. I believe in the misdemeanor case, his phone privileges were already revoked, but I'd like that to also be in order for the felony one, just to cover all bases. And then the second issue is that at his arraignment, he was remanded by Judge Simmons because the defendant kept having outbursts. And so I didn't know if the court felt necessary to address bond today or to address it at the exam after the testimony.
Can I speak?
No, Mr. Davis, you have a lawyer for a good reason. Do you need to speak to him?
He never came. I would like to speak on my own behalf, I guess.
No.
That's not a good idea, Mr. Davis. It's not a good idea.
Oh, well, why haven't we spoken, Mr. Freeman?
Well, we're not going to discuss that right now in public. I'll come and see you before your exam, I assure you.
Okay, well...
That's it. That's it. Just hold it.
Can we address a low cash 10% surety bond, please?
You can ask, but it won't be low, Mr. Davis. All right, go ahead, Mr. Pfeiffer, on bond.
Yes, Your Honor. Before all the jail calls, the people filed a bond form requesting $250,000 cash surety due to the defendant's significant criminal history and the level of violence here. This court knows what type of cases I exclusively work on. So when I say it's some of the worst injuries I've seen on my cases, I'd like to think that holds some weight. But I would like permission to, as an offer of proof, share screen at the moment.
Oh, I have to.
And here's the gut punch moment. The prosecutor shows the victim's injuries on screen, brutal evidence that instantly raises the emotional stakes. Question for you. Should courts always allow these kinds of graphic photos in hearings, or does it risk biasing the...
Give you permission. Hold on one second. I have it locked down due to, how
I
people
remember.
behave in Zoom.
I remember.
Okay, let's see here. Oh, that's not working. Let me try again here. Advanced sharing. Share. Oops, one participant, all participants. Okay, I think you'll be able to do it. Let's see how it goes.
Yep. Thank you. That's what her face looked like after she was able to escape from the defendant, who had
There was
been
no escape
holding her
there.
against her will. And
Pfeiffer
again,
is just so conniving.
Mr. Davis, you really should be quiet, young man. Really.
Mr. Davis has now been muted for his own protection, as he doesn't understand he has a right to remain silent and that he may be incriminating himself. Go ahead, Mr. Pfeiffer.
and again, these are the injuries that he has confessed in jail call to assaulting her, unless someone else also then did this afterwards. But they cover her whole body, and they are extensive. He beat her so badly he damaged his own hands. All this is while on bond. And at his arraignment, he confessed to living with her and her being there that day. Now, the people requested $250,000 because my office is worried that he'll kill her. Just point blank. And then, almost immediately, he is calling her through his dad to have the dad send messages to her, then calling her directly, and then using other inmate accounts to call her in order to, in his own words, avoid detection. The likelihood of conviction here, from the people's point of view, is almost a certainty because of the injuries in the defendant's own statements. He is facing numerous life offenses and will be adding an additional discretionary consecutive life offense for the witness interference bribery. I am asking for $300,000 cash surety. I think that is appropriate.
Wow, even the defense attorney, whose job is to fight for the client, admits he can't dispute the evidence here. That tells you just how overwhelming the case against Davis is. When the defense basically says, yeah, the prosecutor's right,
For this defendant, based on not only his actions that led to him being arrested the first time for the misdemeanor case, then the actions led him being arrested for this case while on bond,